And may I be permitted to mention one matter from circuit bench, Jalpaiguri circuit bench. The matter was in the list on the last date, but due to scarcity of time, that was not called on. Now the person has to travel more than 262 kilometers per day. It's about transfer and covered by your lordship's division bench order.
But how can we take it up?
Order. There would be no circuit bench till 27th of October. Mr. Ray is there, my lord. He is representing the
Similar point, my lord, single teacher willingness point, your lordship's covered by your lordship's judgment.
But how can we take it
My lord,
up?
since the
circuit bench is not functioning,
is not functional.
so your lordship
There
can
is
take.
there is a government notification to that effect. You have to bring that.
Well, it's my understanding that, my lord, when it's not functioning, the court can take up the matter.
This list, my lord. This is my application. My learned senior friend is on the other side, my lord. I'm praying for accommodation for the day, my lord.
Who is your other side?
Well, Mr.
Mr. Bari?
Can you take it tomorrow, my lord?
Not today. Taku list. Epril থেকে করি 31st এপ্রিলে।
এটা কাজে লাগবে না
I was directed to file a report. I have already filed.
Yes, Mr.
No, my lord, I have received, my lord, this. My lord, kindly have a look, my lord, the not paginated. This is on
Where is
20
that government notification? That finance department notification?
My lord, kindly have a look, my lord, the last annexure. Dated 25th of February 2016.
Page.
My lord, this is not.
But I failed to paginate.
Last,
In the report, my lord, I failed to paginate, my lord. If your lordships kindly allow me, by seconds I can.
my lord, last annexure.
Last annexure of your stay application?
No. His
Oh,
report.
achha.
25th February 2016.
Yes.
My lord, Roman 4. Terminal benefit on attaining the age of 60 years is 2 lakh.
We will leave that open for you. If your terminal benefits, you have not claimed so in your writ petition. Writ petition, whether your terminal, there is no dispute that you will get the terminal benefits on the basis of the rules operating at that stage.
Yes, I have given only 1 lakh.
What is the-
1 lakh has been given.
You have been given 1 lakh.
Yes. My lord, the first page of the report, my lord.
Also, my presentation also portfolio.
Is she entitled to 2 lakhs?
1 lakh. 1 lakh.
But
But may I clarify the situation? Well, kindly takes off the first page of the report. It says he got 1 lakh. Now kindly skip over 3 pages. Your lordship will get a memorandum dated 23rd of April 2010. That's the first circular in this field. Clause 2 says, on attaining after cessation of engagement at the age of prevailing in their case, they will get an amount of rupees 1 lakh, the modality of which will be worked out soon. Now, in 2011, after 3 pages, my lord, there is a circular dated 16th of September 2011. 16th of September 2011. This was by the finance department, not connected with our case, but in case of all contractual and other my lord, casual workers. The next page, it says clause 6, that they would be paid at rupees 1 lakh at the time of cessation of their engagement. Clause 6. Now, the modality which was referred to in the memo dated 23rd of April, that came for the first time, the next 2 pages, my lord, finance department memo dated, bottom portion there is date 29th of February 2016. Lordship got it? It relates to this SSK and MSK. We are connected with this SSK MSK.
Respect of 2 writ petition, this one.
And this is for the first time this modality was laid down. It says, my lord, 4, that they will get 1 lakh. There are, my lord, 1, 2, 3, 4 points at the bottom. One says 1 lakh may be paid as terminal benefit, and 4, such scheme may be effective from November 2013, that is in the month of in which the first petitioner retired. So for the first time by this memo, the modality as was referred in 2010, that was laid down. Now, 2020, from Panchayat.
This 29 February refers to the memo dated 16 September 2011.
No. Yes. Well, 16 September 2011,
Just a moment.
it says, my lord, that
23rd April 2010.
right, it refers to, my lord, kindly have a look at the 3rd paragraph. It starts with now. Now it may be mentioned that terminal benefit of rupees 1 lakh has been allowed in terms of finance department number 9008 FP, it is 16th of September 2011. Lordship got it?
No, this 23rd April said 1 lakh.
1 lakh, the modality is to be laid down later on. Kindly have a look, my lord. Kindly come back to the 23rd April, clause 2.
Modality will be worked out soon.
That's in 2016, for the first time that was worked out. This 29th of February, in respect of SSK and MSK. And it refers to 23rd April as well as the 11th September, September 2011. Finance.
23rd April is not referred to there.
I'll kindly have a look at the 2nd paragraph. Second paragraph, my lord, it is seen from the copy of the order that the petitioners moved so and so, dated 23rd of April 2010, issued by the Panchayat and Rural Development Department. Since there was no modality, 2 writ petitions were moved, there was a direction. Now, my lord, in terms of 2011, this was laid down.
Why do you say 2011?
Panchayat in 2010 said they will get 1 lakh, modalities to be laid down. Now, finance in 2011, they said in case of all casual worker, contractual worker, they will get 1 lakh. Now, in terms of division,
Where is that? 16 September 2011.
16 September 2011, the very next page, clause 6.
Yes. Now, on this basis, 1 lakh was sanctioned through your decree.
Yes. Now, in 2020, my lord, the administrative power from Panchayat that was transferred to the Education Department in case of SSK and MSK. Now, 12th of February 2021, the Education Department, the next circular, my lord, the Education Department says that the terminal benefit will be 3 lakhs in case of those who will retire at the age of 60. Because in 2009, the persons who are working as in MSK and SSK.
Memo of 12th February 21 was cancelled.
No, that was never cancelled.
You're now in cancellation of memo of 12th February, 2nd paragraph.
12th February, yes. That's another memo, my lord. On the same day, 2 notifications. It refers about 760, while this notification is, my lord, 763.
This is a school education.
School Education Department. It says that they will get 3 lakhs who will retire at the age of 60, because rest of the MSK SSK staff, they were allowed to continue to 65. So the 65, they were continue to get 1 lakh in terms of 2016, and who opted to retire at the age of 60, they will get 3 lakhs in terms of 2021. Now the next page, my lord, 4th of July 2024. It created the confusion. But it says the first line, Finance Department has issued order via memo number so and so dated 7th of March 2024 for enhancement of terminal benefit from rupees 2 lakh stroke 3 lakh to rupees 5 lakh in respect of contractual higher secondary teacher, para teacher, SSK and MSK teacher, academic supervisor, ASHA workers, honorary health worker, Anganwadi workers, Anganwadi helpers. So our series of name is there, my lord. Now, after careful consideration of the matter, the understanding is directed to say that the governor has been pleased to decide that with effect from 1st of April 2024, the amount of one-time terminal benefit for the aforesaid contractual persons pertaining to school education department on any directorate society so and so attaining the age of 60 or 65 years, as the case may be, will be enhanced to rupees 5 lakhs from 2 lakhs to 3 lakhs. Now, this 2 lakh that created confusion. In our society, MSK, SSK, there was no concept of 2 lakh. There was only concept of 1 lakh in terms of 2016. Now, 2 lakh concept, where from it came, my lord, if your lordship stands to the last but one page of my compilation, that's dated 25th February 2016. It's not related to MSK, SSK. It's the Finance Department circular, which my lord covers the other category. It says, the bottom portion, it says the terminal benefit of attaining age of 60 years, rupees 2 lakh. This 2 lakh that has been referred, though it has no nexus with MSK, SSK. Because in MSK, SSK, there were two type of staff. One who were retired at the age of 65, they were getting 1 lakh in terms of 2016. And those who opted for retirement at the age of 60, they were getting 3 lakhs in terms of 2021. Now he continued till 65, retired, got 1 lakh. Now this enhancement of 5 lakhs that came later on.
That is all right, but this differentiation you are making from Finance Department to
Both are the Finance Department circular.
Yes.
Both are the Finance Department circular. But that was never applicable to us. Finance Department on 29th specifies for us 1 lakh, but the same Finance Department for others specified 2 lakhs on 25th of February 2016. That's the thing. But we are guided by the circular, my lord. We are the implementing authority.
but it is the same government, two
Same
different
government.
division.
Same government, but that was never challenged. Till 2016, that was never challenged. Even this writ petitioner was never challenging his writ petition, this discrepancy. He said, I am entitled to get benefit of 2024. Let that be modified. So this is beyond the scope of the writ petition as on date.
Well, I retired 31st December 2023.
Or
This
31st
circular
March.
21st
Yeah,
March
24.
2024.
It came, my lord, from
1st of April
1st of
2020.
April. Now, my lord, the earlier Finance Department memo, my lord, this was lakh, then it was increased to 2 lakhs.
That is for other, that
No,
is for
at
other
least
contract.
just this contractual also.
But that is not your
Now, my lord,
case in the
kindly-
writ petition. That is not the case in your writ petition.
My case is, my lord, that was in the writ petition is I am entitled, my lord, for first
5 lakhs.
5 lakhs.
There was
Well,
no grievance on
no.
your part in the writ petition that you have given me 1 lakh. Did you receive that benefit prior to filing of the writ petition? 1
My
lakh
lord,
must
I
have
have
been-
made that representation, my lord, in my in the state application.
28th of November 2024, he got it.
37.
open for it. We will record. You have also urged about this discrimination practiced by two different departments of the same government.
My lord, if your lordship kindly have a look, page 37 of my stay application, I need a representation there also.
That is for 5 lakhs.
5 lakhs. Now, my lord,
1
eight-
lakh I
When did you receive that 1 lakh?
But November 2024.
24.
That is prior to the writ petition.
Yes, February 2025 writ petition was filed.
No, we will record, Mr. Acharya. That so far as your claim as regards, you are saying that you are entitled to 2 lakhs.
At least,
Huh?
at least 2 lakhs.
2 lakhs. That point you urge before the fresh writ petition.
my দরখাস্তটা
এটা তো এটা তো-
secretary
Now, my lord, representation which I made can be, my lord, directed by the, my lord, the
You make the representation after this. We are keeping that point open.
and
That
Page 37.
representation didn't deal with that point.
This is now when circulars have been produced. We apparently find there is a discrimination.
both are finance department. My
Now
lord, kindly
I
appreciate
have
that.
delivered a judgment wherein I have held in your favor. I said that two different departments of the same government cannot take a inconsistent step. Try your luck.
The appeal is
You got an handle. You got a handle now.
Only rupees 1 lakh. The
Huh?
poor Sahika. Right.
No, not 1 lakh.
No, handle to further agitate.
Agitate, my lord. I admit, my lord, I am, since I retired prior to 1st April, then I am not entitled to that
Right.
terminal benefit.
Correct.
I am only 2 lakhs. I am harping on that. I received
We
1
have
lakh.
kept it open. That is why we have kept it. Yes, next matter.
I am for the requisition and respondent led by Mr. Bari.
I am for the
Oh, এটা Mr. Bari.
Yes, my lord. That matter, my
You
lord,
have
the
seen Mr. Prasad. Is it covered?
larger been judgment covered.
Malute, as Malute, he has improved his qualification in the relevant subject and he was appointed as a he was appointed as a honors and he had improved his qualification Malote as postgraduate in the relevant subject. Malote, it is covered by the larger bench. But only one thing I am pointing out in from the impugn order, Malote, I am seeking some interference on it. If Malote will consider,
No, then tell us what is the matter.
Malote, it is a
Writ petition was preferred challenging what?
Malote, it is the challenge in the writ petition was the impugn order passed by the DI of school.
Where is
Page
that page?
70.
Page
70. 70.
Just give us 2 minutes.
Yes.
Where is the order impugn?
Malote,
81.
yes, Malote, it is page
77.
page 81 onwards of the state application.
is an order of 2013.
13.
You challenged,
And it is contemporaneously challenged by filing the appeal. And my lord,
and now what you are wanting to say?
my lord,
Mr.
only regarding my lord, the direction part. Direction part I want to point out, my lord, page
Interest.
83, page 83.
Uh,
My lord, that is the third paragraph onwards. I direct the respondent number 2 to extend the above benefit of postgraduate scale of pay in favor of the petitioner within a period of 2 months from the date of communication of this order, including arrear with effect from the date following the last date of MSc Part 2 examination of the petitioner together with interest at 9% on arrear. My lord, thereafter the respondent is directed to pay the above interest within the period mentioned herein above from the public exchequer at the first instance. Then, my lord, the secretary to the government of West Bengal School Education Department is directed to recover the aforesaid amount of interest from the salary of the concerned district inspector of school within 3 months or by way of realizing public demand in case of his retirement, and to submit a report to that effect in the office of the Registrar General Appellate Side, High Court, Calcutta, after 6 months. My lord, only what I am seeking, because my lord, if the benefit was extended from the last date of examination and with interest at the rate of, my lord, 9% upon the arrear. Now, my lord, what I am on, the respondent number 3, the DI, the then DI, my lord, had passed the impugn order as per the honorable court's decision. My lord, here what happened, the honorable court had also directed to realize the interest part, my lord, from his salary in case of his retirement from his retirement benefit. My lord, I am only seeking, my lord, that portion to be modified. Because, my lord,
Can we modify that direction, Mr. Prasad?
because what I am humbly submitting before your lordship, that at that point of time, the then DI had passed the order in pursuant to the order passed by in the first round of litigation.
Yes.
My lord, he had done his
Is
duty.
that your ground in the appeal?
Yes, we have taken this ground because this is the only,
The person is still in service?
Yes,
my lord,
yes,
Lead petitioner?
yes.
though it is not his personal capacity. At that point of time, DI had filed
Show
this.
us any authority that when the court says that you have to recover, because the DI in his personal capacity has not challenged the order.
Yes, I bow down to your lordship,
Then
because
how can we touch that same?
my lord, that much,
Touch the same.
that much.
No, you show us any instance by which we can touch the same. Show us any authority on that one. And you kept the appeal pending for more than 10 years.
My lord,
2013 was the writ petition. Appeal was filed 2013.
13 itself, and
13
without
did
any
no
section
stay
5.
order was obtained. There was no stay order.
No, stay.
They did not proceed in contempt. So you were
My lord, I cannot improve over the record. My lord, it was a 2013 appeal and it has been taken up by your lordship for the first time.
yes. That I understand because it was told to us that this issue has been settled by
Yes.
Now, if you, Mr. Prasad, want to argue as regards decision of that direction,
Yes.
you have to show us some authority.
Yes, my lord, as of today, my lord,
That DI has retired,
my lord,
or his pensionary benefits have been withheld now.
my lord, বলছে what কাজ করছে
না না আমাদের পিটিশনের কাজ করে ডিআই
DI
না সেটা
তো স্কুলে আছে না?
my lord, then my lord, that much portion I am pointing out before your lordship, and as a appeal filed by the state respondent, she has not filed, my lord, the then DI, my lord, in personal capacity did not file any appeal challenging the impugn order. My lord, I am leaving to your lordship that this is the portion I just want to argue. Otherwise, we are in case of for my lord, to support my argument for any authority, my lord, today I am not prepared on that issue.
To come with the author.
Yes. If my lord will grant me time, then my lord I will come. Otherwise, my lord can pass necessary because it is squarely covered by the larger bench. Issue
No,
is
you
squarely
give
covered.
us the judgment where he has not challenged the order.
Yes,
you
yes,
declare-
I am understanding. I am understanding, Your Lordship.
You give us that. Give us something on the basis of which we can understand.
My
When?
lord, then,
Come-
my lord, give me let it be after vacation or as your lordship desire. My lord, I cannot. Any day.
তাহলে reopening এ রেখে দিই।
Okay.
Yes, next.
Issue has already been settled, madam.
That I have.
From 2000.
No, he is not disputing that. We will pass that order on that date. He is appearing.
Yes.
Yes.
I beg to appear on the behalf of the state with my senior.
My lord, I am appearing for the state in this matter, my lord.
কি audible শোনা যাচ্ছে না?
Yes, I beg to appear. The matter relates to substitution. What happened, my lord? After filing the memo of appeal, the sole petitioner died. Therefore, substitution application filed, my lord. Or it is an admitted fact that the
Just a
Well.
Mr. Prasad, why you are going beyond the vacation?
As your lordship desire. If it is, I would
Korea
Yes,
appeal
yes,
is
I
pending
am
for
not-
more than 10 years.
Yes, yes.
We
Let
do
it
not
be
know
any
whether
day, my
you
lord,
will
and next week.
You come on Monday with any authority.
Yes.
Otherwise,
I
and
will be-
otherwise we will hear him, and as
Yes.
regards that direction, we will consider. After vacation, we don't
No,
know
no.
what happens after
I am not arguing on that issue, but
the
if whatever my lord decide, I
সোমবার রেখেছে, হ্যাঁ।
Monday.
Monday, if any authority, you
Yes,
come
yes,
and
I
tell
will
us.
decide, otherwise I.
In Utpalman, whether this sort of an issue was there, if there is a direction, payment of interest, etc.
No,
No, my
Manu, because
It
it
is
is on
only on the
deference.
question of entitlement.
Entitlement is on deference, four or five. Manu,
So, sir, you also take instruction whether you will forego that 9% or not.
because it is a admitted position, Manu, he had made her. His
All right,
claim.
come on Monday, we will dispose of. হ্যাঁ, বলো।
matter substitution.
Substitution.
Substitution of the sole. What happened, my lord? After filing the memo of appeal,
My lord, before my learned senior friend moves, my lord, we have not, we have not served with the substitution application, my lord. If your lordships remember, my lord, on the last occasion, lordship has directed to give us the substitution application, my lord. But till date, no substitution application has been served, my lord, to us.
What is
My
the
lord, my lord.
what happened, my lord? After filing the memo of appeal, the
Yeah.
sole petitioner died.
petition after filing memo of appeal?
Memo of
petitioner-
appeal.
Huh.
Sole appellant died.
Hmm.
So I could not file the stay application, my lord. Therefore, I have come with substitution application.
Oh, you are opposing the substitution.
No, my lord, I am not opposing, my lord. If your lordship remember, this matter was taken on the last occasion. Your lordship directed my learned senior friends junior to serve us with the substitution application, my lord. But till date, my lord, we are asking for it, but they are not giving it, my lord. That is the,
It is being handed over to your junior tomorrow to be mentioned.
my lord, deeply obliged, my lord, deeply obliged.
Tomorrow you are in problem.
Make it on Thursday, your lordship.
May I play one thing?
Sure, sure, sure. কি বলছো?
Madam, may I play one?
দাঁড়াও, দাঁড়াও, দাঁড়াও।
মঙ্গলা হচ্ছে অ্যাপারেন্ট ছিল,
মঙ্গল
হ্যাঁ, আর দীপ্রজিৎ হচ্ছে নাকুল কাকলি মেয়ে, আর দীপ্রজিৎ নাকুল।
Mongola was the appellate.
Mongola was the appellant.
She
He
now-
died after filing the memo of
then
appeal.
who are the heirs?
We are the class 2 years, my lord. We are daughters, sister's daughter. Class 2,
Mongola has no issue.
no issue. No issue.
Kakoli is the
Uh,
sister.
Applicant number 1B is sister's daughter and 1A is grandson.
Sister's daughter's grandson.
No, Mongola's grandson. Son of Kakuli Bhattacharya. Daughter's son. Sister, daughter's son.
So sister's daughter's grandson is
No,
Diproji.
sister, daughter's son is
Correct.
1A.
Kakoli is the sister's daughter.
Sister, daughter's
Diprojit is Kakoli's son.
Kakuli's son.
So sister's daughter's grandson.
Yes.
What was the claim for in the writ petition?
No, my lord, claim is regarding family pension. Family
Family
pension,
pension, you have to satisfy us, you come within the arena of family definition. Otherwise, why should we substitute?
my lord, certainly, my lord. My lord, the writ petition filed by Mongola, she was eligible for family pension. That was not granted by relying by the learned single bench by relying the Abhijit Boidya case. My lord, very well known, there is a different view after Abhijit Boidya pronouncement by different benches. My lord, if the Mongola was alive, then he was if she succeed, then he will be eligible for family pension
What did the trial judge say?
by relying Abhijit Boidya, my lord. CPF to GPF না এখানে থাকবে ও মেমো মেমো মেমো
Video আর কি? Video not
মেমোটা
entitled to
this one
hold করবো।
ওই ম্যাটারটা পেন্ডিং রেখে
হ্যাঁ, Supreme Court এ আছে তো না CPS তো
You have to deposit the entire amount now. You are ready?
yes my lord
Huh?
yes
Yes.
yes
You are
because
in-
my entitlement was very small my lord on that point of time I got 3,000 or
No,
4,000
let us understand.
my lord
Your entitlement, if at all,
yes my lord
entitlement was of Mongola. Now, Mongola had been entitled, Mongola would have to return the entire
My-
CPF
lord,
contribution to the government.
we are ready
Eh?
we are ready
Where have you stated that? In your substitution?
I am submitting before your lordship my lord my lord
Mm.
can record it my lord can record it
Has not yet been
and if my lord desire then I can submit it in my stay application still now filed
It's an opposition to this and come. Because the difficulty is you do not come within the zone of consideration within the family definition. First, second is this point is right that had I been alive,
my lord.
I would have got family pension for a particular period after refunding the CPF part. That we accept. But how much is your client must know? Your client will not be getting pension.
no
only the accrued amount.
Only the accrued amount.
yes
she-
yes only the accrued arrear amount
But
accrued
then you
arrear
have to
amount
show us which
we are not
period-
entitled we are not entitled to family pension my lord we doesn't come within the family definition
Huh.
we are not at all entitled for pension
So
but
very good. You
but
that
if-
is not
if-
your cause of action. You
if-
prefer that
if Mongola succeed, it is a pecuniary benefit, my lord. It is admitted fact. It is a pecuniary benefit. If Mongola holds the amount, then we are the successor of that property.
are showing
That is my humble submission, my lord. Before your
So,
lordship.
but you tell us which period and how much will be the amount.
please talk with your client.
The particular.
Suppose today we should not pass an unimplemented lot.
Certainly, my lord, certainly.
So you talk with your client that as per the calculation, sir, you have to deposit this to the government. Then only the court will say whether you will be then after, if you are agreeable to that, I can approach the court for it.
May I submit one thing, my lord?
Uh.
I already consulted with my client.
So show us what is the amount you have to return.
The-
Do
my
you
lord,
know
ca-
what is the amount to be
My
returned?
lord, kindly allow me to file the stay application. I shall submit in my stay application entire calculation. What amount I shall deposit by adding at least statutory interest. I am ready. Because my entitlement on that period on the ground of CPF was just 3,000
You
something.
come with an who is there? We are giving this copy. You give
My
it
lord,
to
my
him, and you come. You take instruction and come ready and argue whether the substitution at all we will consider or not.
My lord, my lord.
এটা দিয়ে দাও।
My lord, kindly allow me to file the stay application at least so that I can come my details.
Unless you are substituting.
Certainly, my lord, that is the problem.
So you
That is the-
file a short affidavit to this application.
Yes, your
And
lordship.
let us, we will decide that point and we will add.
If I supplementary affidavit, your lordship.
When he will be opposing by an opposition, in the reply, you annex the calculation.
Suppose those particulars.
Fine.
You know, so
By in course of today, I shall submit. I shall submit.
Dated 17 January 2025 is under challenge.
by 26th, he will file it by 5th November. We have kept it on 10th.
On 26th October, your lordship.
Huh?
On 26th October, your lordship.
Not October, September.
September.
Yes, yes, next.
I beg.
Oh, you are there.
Right.
Yes, tell us
This
what.
matter relates to
Hello, beg to appear for the state respondent.
uh, but I was a teacher, assistant teacher of a government
Why it is defective?
effective.
No, bhai.
Was defective but
Name of the respondent number 4 does not find respondent number 4.
Subject to correction, my lord, defect has been cured.
Where? Oh, defect cured.
Subject to correction, my lord.
Corrected in terms of court's order 28th February.
My lord,
কি বলে?
my lord.
There is no 28th February order. There you correct. Yes, tell us what is the matter.
কি defect ছিল?
Where is the order impugned?
My lord, in my memo, my lord, after page 5.
It's a longish order. What is the subject matter?
Subject matter, my lord, I was assistant teacher of a government sponsored school. Now, in the on specifically on 16th June 2003, one vacancy notification issued by the said school regarding appointment of assistant headmaster or headmistress. When the notification was issued, I was under suspension. But I got the knowledge from the school concern. I made an application on 19th. On 16th, the notification issued. On 19th, I made application.
Suspended when?
Suspended, my lord, on 27th September 2002.
Since then you are under suspension.
Suspension.
Till date.
No, till that date and till 2012.
How can be 2012? 2022 you are suspended.
2002 I was suspended.
2002.
2002.
And your suspension was operative on the date of notification.
My lord.
When was it lifted? Suspension?
Lifted on 2012 by the order of this honorable court.
By order of this court, suspension was revoked. Where is that order? That is here.
That is
an annex.
yes.
Achha, very good. Then what happened? You tell us.
Thereafter, my lord, on 19th June 2003, I made an application before the authority for participation in the interview for the post of assistant headmaster or headmistress.
19th
19th June 2003.
2023.
No, 20.
Notification was the 16th June 2020.
2003.
2003
কি বলে বুঝতে পারি।
16th June 2003.
19 June, you say.
16th June notification issued.
16 June 2002. 2003.
My lord.
And you were in suspension at that time, which was revoked in the year 2012.
My lord.
Very good. Then you applied for that post.
19th June 2003.
You applied.
I applied.
Then what happened?
But no opportunity extended in favor of me. Therefore, I approach before I come before this writ court, and prior to that, I made several application before the concerned authority and higher authorities.
19 June 23 was your application. When was the interview?
That was not informed to me.
Achha,
But select after selection, I got the I got that selection. My lord, on 23rd July 2003, I made an application before the higher authority.
You should come with a list.
After
of
knowing the
dates,
knowledge.
Mr. Hathi.
Memo.
So now that post has been filled up.
Yes.
2003, as far back as in the 2003, that has been initiated, filled up in a suspension condition, my lord, he is claiming to be appointed, which was lifted in 2000 as AHM, assistant additional headmaster. Now it was lifted 2012. By that time, some person has been appointed, he worked, now he is in age of 64. If petition was affirmed, additional point.
Petitioner is 64 years.
Now, as of now, a date. Now, how the clock can be set back, appointing him in 2003,
giving this benefit, removing someone who has still worked till her superannuation, now he has been superannuated. This petition itself become
Why didn't you call him for the interview? He was in suspension. His service tenure was not interfered with. But he was in service, but under suspension.
But HM post, my lord, it is between inter say between in the school itself.
Right, right.
So
Inter say the staff of the school.
school.
He was a staff. He
He
was
was a
suspended.
staff. He is condition
There
staff.
was not severance of any employer-employee relationship.
No.
He was a staff, but you did not call him for the interview.
Since my lord, although my lord, it is for the school to appraise your lordship, but may I say that since my lord, it involves a suspended teacher, how he is already suspended.
Suspension was revoked in the year 2012.
12.
Where is that court's order?
How a suspended teacher, my lord, can be posted and be appointed and allowed to join?
In my
What did the court say?
in my stay
Yes, my lord,
application,
my
my
lord.
lord, 103.
And after 2003, my lord, this writ petition is of in the year 2008. That has been that as a point was specifically taken by the state, my lord.
Yeah, just so.
My lord.
103. No, 30. It was 2012.
So, Mr. Hathi, you did not challenge. You did not challenge such inaction when you were challenging the order of suspension. By the time this order was passed, the entire story was over. 2012, you filed the writ petition saying that you cannot keep me under suspension since the disciplinary order has been disapproved by the
Disapproved by the DSE.
Now, in 2013 order, you joined. You retired when?
I retired on 31st January 2019.
31st January 2019. So in 2013, in 2012, when you filed the writ petition, you did not take the point that by virtue of the suspension, I was not called for the interview. Now, how we can help you?
My lord, what I want.
Mr.
I-
Just suspension was of 2002. Its suspension was revoked in 2012. Huh?
30.
That is after this court's order.
Right.
When the suspension was revoked, when you preferred the writ petition, you did not agitate this point that in the meantime your case was what? I was suspended. You did not call me for the interview.
No, that was not my prayer, my lord. That was not intimated to me due to suspension. They did not call me.
So how
They
can
didn't give any reply even.
So how can you re-agitate here?
I agitated my claim in the year 2008. The writ was 2008.
Very good. Then you did not obtain in order here. 2000, not 2008. Where is 2008 order? 2012.
No, my lord. 2012 order of revocation of suspension. 2013 writ of 2012, 2013 order of revocation of suspension. The selection process initiated in the year of 2003. I made the writ petition for inaction to not to call for in the interview on 2008.
in this writ petition of 2012.
No, 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 no. Prior to that,
Where
another
is
writ
that
petition.
writ petition?
That is the
That we,
in that writ petition, the impugned order has been passed by the single bench. My lord, kindly come.
page 17 is
Page
the
17.
writ petition.
Oh,
Page 17. 2008. I agitated my grievances on 2008.
did you obtain any interim order?
No.
Now, what remedy lies? Headmaster assistant was filled up.
Certainly, my
You
lord,
have
everything
declared-
over all persons retired. It is admitted. But it is also admitted the violation was there. I had a right to at least participate in the interview.
That you should have taken when you filed the 2008 writ petition. By that time also, interview was in 2003.
Yes, that was the ground of the single bench.
Achha,
Honorable
let us
single
see
bench,
what
that was
the
the
judge
ground.
has said.
Yes,
What
my
the
lord.
judge has said.
My
What
lord.
is the reasoning? Let us see.
106, my lord.
জোর করে লড়াই করে দুটোই দিতে হবে তাদের। লিখে পেতে তো একটা গ্রাউন্ড ছিল কিন্তু নেই।
Achha, when was the one-man panel prepared? That person was appointed when?
That
That
person was
person-
appointed on 23rd July 2003.
Three.
So far, I have got the information, my lord.
23rd July
July
2003.
3.
2003.
My
That
lord.
prior to filing of your writ petition.
Prior to filing my.
In 2008.
That was, I agitated that point before the higher authority.
No, no,
My
we are asking you,
My lord.
when you filed the writ petition in 2008,
Eight.
selection process was over,
Over.
the person was appointed.
My lord.
Did you implicate that person in the writ
Yes, yes,
petition?
yes.
Eh?
Yes.
Yes, ma'am. Not page 21. That's point number 9. Mohuwa Dasgupta.
এখন তো আর কিছু করা যাবে না।
না।
How can we help you, sir?
My lord, may I submit one thing? I know, my lord. I know.
So when you know why you are,
If there been a good
we will
case,
not
he
record
died.
that you will know.
I know, my lord, but only one thing, my lord. If my lord, it is a court of law, my lord. If violation is there, my lord, violation of, no, I had a right to participate at least.
Then why didn't you say at that time?
I say, I approach,
2008.
not only before the writ court,
even
prior to that,
after 5
I
years.
approach before the higher authorities also. My lord, kindly take table to come in my
Hmm.
application, page 14,
Yes.
page 14,
Page 40.
40, my lord. Detailed, I mentioned before the secretary, headmaster, and also the DI.
Mr. Hati,
My
if the representation is not considered, was it not incumbent upon you to immediately come to court? Because the post was being filled up
Submit.
today.
Fine.
Today, suppose we accept your contention,
Fine.
you are no longer in service.
Fine.
Now we have to say that you treat him as an assistant headmaster from that date.
My lord.
Is it possible? এটা হয় নাকি?
My lord, may I submit one thing, my lord?
A
I have-
representation you made in 2003, but you did not file a writ petition.
I'm trying to explain that delay, my lord, that I have taken in my writ petition. My lord, on that point of time, I
Page
that ground of explanation of delay that I have not
Not,
taken.
no.
That it is admitted that I have not taken. But what I am submitting, my lord, but what I am submitting, my lord,
আর
on
কিছু
that
করা যাবে না। আসো, the present writ petition.
some time, my lord, maybe
হ্যাঁ বলো,
some time.
কি পুজোর আগে ডিসমিস করবো না? এ হয় নাকি?
My lord, kindly give me some time. If I got any authority, my lord.
Come with a better case.
I know, my lord. It could have been a good case in time.
Yes.
Yes.
But one thing, my lord, I want to highlight to your lordship.
ও দাঁড়াও, বলে দিক।
My lord, it is admitted that I was under suspension. It was also admitted that in suspension I was entitled to get substitution allowance. That was not given.
আরে
my lord,
that-
I come before this court.
that was not the
That
subject
is
matter.
litigation expenses I could bear.
No, that-
Wow.
That was litigation expenses I could bear, my lord. That was not with me.
আরে Mr. Hati, your interview was over in 2003.
My lord.
Person was appointed. You went on making represent. At that time, that client did not meet with Mr. Hati. Otherwise, you would have said that immediately file a writ petition. Let's go to the court. We will obtain an order. Let us see how, you know.
Only one accommodation,
আবার কি?
the honorable single judge dismissed my writ petition on the ground of delay. But kindly why not waive that part?
My lord, not only delay.
My lord,
But Mr. Dey,
remind the
sorry.
matter before the
My apology.
trial.
why you are saying not
My lord,
only
sorry.
delay? Not
No.
only delay, why you are saying?
No, other point
What
also.
other point? Only on the point
My
of
lord.
delay.
Okay.
Yeah.
The appeal. I am preparing for the UGC University grant.
This
I'm
is
for
my
the
appeal, my lord. This intra-court appeal, my lord, pertains to a process of selection.
My lord, I am appearing for
undertaken
the
by
College
the
Service Commission led
College
by
Service
Mr.
Commission.
Panda. My lord,
Apropos the post of assistant professor, my lord, in various government-aided colleges. Lastly, the matter was taken up by your lordship on 29th of July. Your lordships were pleased to direct, my lord, the respondents to use affidavits. Till date, my lord, we have not been served with any affidavit.
Well, it has been lately prepared and I'm filing it today with your lordship's leave. I can hand over a copy to him.
my lord, for the College Service Commission, I am not ready to go with opposition. My lord, kindly give us more time. My lord, to file the affidavit.
Right, the direction.
My lord, my lord, my lord, this is my senior difficulty.
File we will not
No, my lord, it is very necessary to file the affidavit. This is my very necessary to file the affidavit. My lord, my lord, my senior some difficulty so that I could not. My lord, give us time, my lord, after because.
Yes, my lord, this pertains to a process of selection undertaken by West Bengal College Service Commission apropos the post of assistant professors in various government-aided colleges. My lord, the basic, my lord, grievance is, my lord, that ineligible and less meritorious candidates have been, my lord, recommended and ultimately appointed. Number two, my lord, post is of, my lord, assistant professor, my lord. Here we are concerned with the subject matter, my lord, Shanthal. There was only one unreserved post notified. My lord, I will
participate.
yes, I
But you
participate.
were unsuccessful.
Unsuccessful.
Now challenging the entire selection process, you file writ petition there.
Yes.
Now writ petition dismissed. You are in appeal. So how do you come across the first hurdle? Having participated, you cannot challenge.
My lord, I, my lord, seek to, my lord, cross the first hurdle on the ground that there are, my lord, illegalities which are apparent from record, which has, my lord, surfaced, my lord, on the basis of a supplementary affidavit which was used by the College Service Commission immediately prior to the date of closure of hearing. My lord, I can
Prior to
the date of, my lord, date on which the hearing was closed in the writ petition. My lord, I have prepared a chart, my lord, which is appearing at page 11, a comparative chart. I can
of your stay application.
of my stay application. I can, my lord, demonstrate that these candidates who have ultimately been appointed, they were not even eligible to participate in this election process.
Have you made the selected person a party?
Yes, and
Appearing for her.
my lord, they did not appear in the writ petition. On the last occasion also nobody appeared. And pursuant to your lordship's last direction, I have once again, my lord, served.
So the student and the other.
My lord, there are three, my lord, selected candidates.
So, section 5 টা allow করে দিয়েছে।
My lord, I am for. Lord, I appearing. Lord, I am appearing. Lord, I am appearing on behalf of the West Bengal College Service Commission. My lord, my difficulty, it's my personal ground. I could not be prepared, my lord. My lord, that's why, my lord, I am paying for, my lord, 2 weeks times, my lord, because it is my personal, it is my fault. I am accepting. My lord, kindly allow, my lord. Otherwise, my lord, it's my.
So, Panda,
my lord,
file it within 1 week so that they can use a reply to both affidavits together and we can come back in November.
my lord, one week after, my lord, because my lord, I have some problem. My lord. Kindly, it's my.
Personal problem.
I have some personal difficulty.
When do you want to? When can you file it?
My lord, after 1 week or 2 weeks after vacation, my lord.
Weeks after vacation.
1 week after vacation. 1 week after vacation. My lord, I can, my lord, prepare within during the vacation, my lord.
We file it by 6th November. He will file reply dealing with of the affidavit
Ma-
on 1st of November. Matter will come 17th November.
My affidavit এটা দিয়ে দিন।
হ্যাঁ The 6, I am for the appellant petitioner. Lord, I am for the respondent counsel. Because for the state. Can 2 is the application for condonation of delay, my lord. The delay of 68 days to prefer this appeal. Yes, yes. After the impugned order was passed, my lord, the appellants herein, my lord, preferred and special leave petition before the Honorable Supreme Court, my lord. That was withdrawn. Thereafter, my lord, this appeal has been filed. That was withdrawn and dismissed as withdrawn. My lord, I am raising the maintainability issue because it was without any leave that he can challenge before this Honorable Court.
He went directly to the Supreme Court from the
Directly, my lord, from the single bench order, he had gone to the Supreme Court by filing SLP, where he had withdrawn the case without my lord securing any leave that he can approach this Honorable Court. Well, no leave is required, my lord. Before the Supreme Court, my lord, it was raised why we did not prefer appeal before the division bench. That is why it was withdrawn before the Supreme Court. It was withdrawn as dismissed, my lord. Merit has not been considered by the Honorable Supreme Court, and he was not present before the Supreme Court.
No, but he can raise the point if he was not
At
present.
the very first date, my lord, it was dismissed as withdrawn. My lord, page 265 of my application for appropriate order. Yes, my lord, may I please? Well, this is part, your lordship, my lord Justice Chakraborty is familiar to this matter, my lord. This is pertains to 2009 recruitment process conducted by the District Primary School Council, Malda, my lord. My lord, what happened, my lord? This recruitment is of 2009, my lord. Advertisement is of 30th August 2009. My lord, examination held in the year 2012, but due to some allegations of nepotism and favoritism, my lord, it was cancelled and directed to be conducted de novo. My lord, de novo exam was supposed to held in the year 2012. My lord, it was stayed by this by a order passed by this Honorable High Court, my lord, and after, my lord, the stay was lifted, my lord. The written examination was held in the year 2014. We participated in that written examination, my lord. Well, the result of written examination was published in the month of January 2015. Well, we qualified in the written examination. We are called for interview, participation in the interview, my lord. Well, interview held in the month of February 2015. We participated in the interview process, my lord. Well, thereafter, what happened, my lord? Panel was prepared. It was approved also, but it never seen the light of the day, my lord. So the writ petition was filed before this Honorable High Court, my lord, praying for yes, my lord. My lord, it was gone up to the Supreme Court, my lord. Well, Honorable Supreme Court remanded it back to this Honorable High Court, my lord, directing the Honorable Chief Justice of this Calcutta High Court to form a special bench to decide the issue, my lord. Your lordship sitting singly heard all the matters pertains to Malda and
Not pertaining to Howrah.
no, this is pertains to Malda, my lord.
And that was
North 24 Pargana and Malda. Your lordship decided the issue pertains to North 24 Pargana and Malda.
word of the
I'm from Malda.
that
Your-
Nihar Ranjan Chakraborty.
Yes, madam. Nihar Bishwas, madam. Nihar Bishwas relates to North 24 Pargana and Murtuja Ali and Ranjit Jha relates to Malda, my lord.
What happened?
My lord, pursuant to your lordship direction, my lord, panel was published in the month of February 2021. Yes, my lord, appointments were given, my lord. My lord, since my lord,
Your writ.
no, my lord, I didn't prefer any writ petition, my lord. Pursuant to that writ petition, panel was published. We were not in the panel, my lord.
Oh, the Malda panel was also
Yes,
published.
yes. Panel was published in the month of February 2021,
Then
consisting of 1320 candidates, my lord. Your lordship's direction was to give appointments to all impanel candidates, and if there are no vacancies, to create.
320 was the panel,
Yes, your lordship.
but you were not there.
Yes, my lord.
Yes.
Your lordship's direction was to provide appointment to all the impanel candidates. Yes, my lord. My lord, thereafter, what happened, my lord? An RTI application was made in the month of November 2022, my lord. My lord, seeking information with regard to non-joining vacancies against those posts. After publication of panel, my lord, since your lordship's direction sitting singly was
like this, that if there are no vacancies, vacancies should be created. So the yes, I am coming to the point. Some right is in favor also. After
Mr. Prasad is there to destroy your right.
yes, he is opposing all throughout, my lord.
Also.
My lord, after publication of panel, my lord, supernumerary post was created pursuant to Malda, my lord. 1,600 post was created. Yes, by notification dated 17th/9/2021. I have annexed the notification also. Since there are no vacancies to accommodate the impanel candidates. Well, thereafter, what happened, my lord? My lord, RT application was made, my lord, seeking information of non-joining vacancies. Since the processes of 2009 and appointments are provided in 2021. By this time, 12 years passed. Yes. My lord, in the RTI application, my lord, it was replied that 431 candidates did not join in the post. So, my lord,
Then November, you were not in the panel.
no, my lord. No, I am not in the initial panel.
My lord, I also, yes.
Understand? November 22, what happened? Panel published.
February 2021 panel published 1320.
And it was expired on February 2023.
It was published on February
2021.
That panel you were not
No.
there. Then you made RTI.
No, thereafter, supernumerary post for accommodating the impanel candidates was published on.
Yes, that is the point. You were not there.
Yes, my lord, that's true. My lord, I am coming, my lord. My lord, since my lord RTI reply reveals that there are still 431 vacancies left, my lord. Several writ petition was filed before this Honorable High Court in 2022. My lord, in those writ petition, my lord, by a consent order of all the parties, my lord, this Honorable Court directed to provide appointment to all the writ petitioners. That order was
Even in the panel.
no, not at all. They were similarly placed like this appellants before your lordship, my lord.
Then that order was not challenged.
I am coming, my lord. But that order was passed on 26th of April 2024. Well, in that order, my lord, two conditions was mentioned. One, the candidate has to participate in the interview process. And two, the candidate has to prefer writ petition prior to 25th April 2024.
Interview process means they wanted to take fresh interview.
No. Interview process that happened in 2015, which these appellants also participated.
Achha. So first was those who participated in the interview.
Yes, to qualified the written examination and participate the interview process. And second point is a cutoff date has been fixed, my lord, by which, my lord, persons who have preferred writ petitions, those writ petitions are allowed. That cutoff date is 25th April 2024.
That is prior to the date of the order.
Just one day prior to the order. Well, consent was recorded 2 times in this order by the.
Preferred the writ before 20.
No, Lord. Well, in this order, my lord, consent was recorded. Consent of DPSC and state has been recorded 2 times, my lord. Even after, my lord, they preferred appeals before the division bench. Division bench said
that order.
Yes, the consent order. Challenging order dated 26th April 2024.
That was challenged by the council.
Council as well as state.
Achha. Then what happened?
In the appeal, my lord, division bench held that since consent has been recorded, you cannot prefer appeal. There are other remedies, my lord, you can avail. My lord, appeal was dismissed. Both the appeals were dismissed. Well, thereafter, my lord, DPSC, District Primary School Council, Malda, preferred a review application before the same bench of Justice Mantha. That review petition was heard on 25th September 2024.
Sure. Huh? Yes, review was on?
Review petition was heard on 25th September 2024. Review filed by DPSC only. Well, in the review, my lord, DPSC raised the point that we have not given any written consent. And council also changed, my lord, the learned advocate who was previously appeared for the DPSC. Well, in the review, my lord, His Lordship Honorable Justice Mantha was pleased to recall it, His Lordship's earlier order, my lord, directing appointment. So the order, my lord, which says giving appointment to all the petitioners.
26th April.
Yes, my lord. Order was recalled and matter was directed to heard fresh by the judge who has determination at that time, my lord. My lord,
Then what happens? to
yes,
the
my lord.
appointment?
Thereafter, my lord, those writ petitioners who are the beneficiaries of order dated 26th April, they preferred an SLP before the Supreme Court, before the against the order of review direct to the Supreme Court. Well, the Supreme Court says by passing an order dated 20th January 2025.
So, actually, you are doing it from the very beginning. Yes, sir.
In the SLP, my lord, the Honorable Supreme Court was pleased to restore the order dated 26th April 2024, directing that since consent was recorded, you cannot deny the consent, and the mother order directing appointment was restored,
So the recalling of the review was
dismissed. Yes. Well, after, since the SLP was allowed, contempt application was filed before this single bench. Since the original order has been restored,
By contempt application was
filed.
filed. Those who not were appointed till then.
Yes. And in that contempt application, they have complied the order. They published a panel dated 27th February 2025.
This panel again, you were not there.
No, since I did not prefer writ petition before the cutoff date. Well, only two things I need to submit before my lords. Well, first, my lord, RTI reply shows there are vacancies of 431 non-joining vacancies, my lord. Against, my lord, they have published a panel of 312 candidates. So there are
Overcome this hurdle.
Yes, my lord, I am coming to that. But so there are still 119 vacancies are left, and we are similarly placed candidates who are the beneficiaries of order dated 26 April. This is the point number one. And second point, my lord, they will certainly raise objection that we have filed our writ petition after cutoff date. And those who have filed writ petition after the cutoff date, those writ petition has already been dismissed. And those have been challenged in the appeal. In the appeal also, that has been dismissed, and that has been quoted in our impugned order also, my lord. But our contention is that we are not praying for extension of cutoff date, my lord, where we are before you, my lords, that we are seeking similar relief since there are non-joining vacancies, and since this post has been created pursuant to your lordship's order sitting singly, my lord, this supernumerary post has been created. This should be used for these 2009 participants only, and these vacancies, these non-joining vacancies should not be carried forward to the next recruitment process. We have got the RTI reply also. Our score is also very good. But to some extent, my lord, more than those who got appointment also.
But your fate was sealed on 26th of April 2020.
My lord, I can show my lords one instance, my lord, in case of Howrah. My lord, this is not a single.
Supposed to give the benefit to you. Entire Pandora's box would be
Yes.
Everybody will come and say, give us appointment.
Yes.
My lord, only 119 vacancies are yet to be filled up. My lord, there is no scope to appoint more than what has been left to be appointed. And
But how can we modify the order of 26th April?
no, we are not seeking modification of that order, my lord. I shall show your lord, my lords, and one order, my lord, of Howrah, my lord. This is not a single instance where consent has been given. In respect of Howrah, consent has been given first. In
Consent, we are not concerned. We are concerned about your claim Your claim has died a natural death for not having preferred any writ petition prior to 26th April. How do you come out of that hurdle? If you cannot come out of that hurdle, then the ball is in the court of the council. Now it is their administrative decision whether you will be accommodated or not after the entire scenario is on. We find this that you have the maybe a better place in the panel which was published on 27th February. You are not
No.
there.
No. Since I did not prefer writ petition prior to 25th of April.
Then you have filed the writ petition after there was your RTI reply was of November 2020.
Yes, that was by some other candidates.
No, some other candidate.
That was by some those persons. Yeah.
Mr. Prasad, can you help?
My lord, they are the unsuccessful candidate.
If your lord, if
My lord, and this issue,
this is an order passed this is an order passed in respect of Howrah, my lord, where even after raising objection by the state regarding consent, my lord, the court has passed an judicial order since there are vacancies.
To overcome Mr. Prasad's submissions as regard maintainability. Order 222 is clearly on your.
My lord, before the Honorable Supreme Court, it was merit has not been considered at all. My lord, he was not present before the Supreme. It was only the query of the Honorable Supreme Court was that whether I have preferred any, why I have not preferred any appeal before the division bench, my lord. That is why we have withdrawn the application.
Not in black and white. Come to the order 265.
It says only permit.
How many candidates?
Yeah.
29.
my lord, only
Mr. Prasad, you are seriously opposing this.
my lord, seriously opposing because this, my lord, the person who had filed their writ petition after that cutoff, my lord, 25th April, their writ petition was dismissed by the single bench. They have preferred appeal before this honorable court and saying that we are better candidate, These are all contention that my learned friend is submitting before your lordship. All had been, my lord, in their appeal. Or coordinate appeal bench has, my lord, categorically, my lord, dismissed those appeal, saying this cutoff is inflexible, inviolable. My lord, I am showing this judgment. Kindly consider. And this cutoff was, my lord, upheld up to Supreme Court. There are 3 districts. The similar order passed: Howrah, Nadia, North Chব্বিশ Pargona, and Malda. My lord, after this, my lord, the division bench, after dismissal of this appeal by the division bench, saying that the cutoff is inviolable, inflexible, they have preferred appeal before the Honorable Supreme Court. Honorable Supreme Court, my lord, summarily dismissed their appeal, my lord, observing that they are the fence sitters. Here, my lord, this person is an unsuccessful candidate. My lord, we had fought.
Single bench judgment in Nihar বিশ্বাস was passed.
Yes.
There was publication of the panel.
Panel who are the Malda also.
The panel which they
Name was not there. 2023 panel expire.
after this 26th April 2024 order that was passed.
Now, my lord, those are the persons. Those persons are the unsuccessful candidate. My lord, they had pursuing their remedies. They are saying that there are some left out vacancy. Kindly consider. Now, in that particular aspect, the Honorable Single Bench, my lord, taking instances of the Howrah district. In Howrah, there is a first order on consent. My lord had passed a consent order that yes, these persons are pursuing their remedies for a long period of time, and they have been called for interview. We are fixing a cutoff. This is the cutoff. By this time, they should file their writ petition. Otherwise, their writ petition will not be.
174.
170.
Well, they cannot deny their consent. Now they are saying that
Ota
has imposed
my lord,
consent.
we are not denying. We are saying this issue is already.
Some very
Yes, my lord. 174, my lord. 174.
I am only
These are
placing.
fresh copies, my lord.
The 26th April is.
My lord, in the compilation that I have handed over, in the compilation that order is there.
My lord, appeal.
আরে কম্পাইলেশন আমি দিয়েছি আর কি। আরে কপি বলতে ওটাই তো তোমার মাসারউদ্দিনের।
May I submit only one?
My lord, page.
Your contention on the stay application as regards maintenance.
Yes, my lord, and let the but this writ petition either on merit or, my lord, in the point of maintainability. Of the compilation, this is the coordinate bench decision, my lord, considering the same issue.
May I submit just one thing?
Kindly consider.
Like in these
My lord, in consideration of already as it is no more res integra. না দুটো দিলাম তো। ও একটা।
Well, in
No,
this
no, no,
matter, well, in
having
this
two
writ
copies.
petition, the specific prayer of the petitioner was
Kindly
to extend the cutoff. Well, Rakhi Chakraborty, I think he is referring to Rakhi Chakraborty's matter. Rakhi Chakraborty's matter.
In and others.
No, page 35, Malas, he is referring.
My lord, the very in case of Malda district, that is the very first order, single bench order, and I am showing the page 35.
Well, in Rakhi Chakraborty's matter, he is referring up. Here, the contention of the petitioner is that he has affirmed
No.
the writ petition within cutoff date. But
Everything
filed it
has
after
been
cutoff date.
considered. Kindly
That was
consider.
decided by the division bench. That was not on this point, my lord.
Everything has been
And
considered.
I'm not praying for extension of cutoff date. I am praying and separate order, my lord, pursuant to non-joining vacancies, my lord, since we are.
You have
Since, my lord,
indirectly it is a relaxation.
Candidates, my lord, they come and say that we are giving consents, and now in our case, my lord, they are seeking time,
No.
my lord. We are equally eligible. Well, mayor file.
If that argument is accepted, we are accepting that argument. But you were not a writ petitioner prior to that.
Yes, I'm grateful to that.
That verdict. Now you are saying on the fringe issues you are proceeding. And ultimately finalize then to how does that benefit you? It would have benefited you had you filed a pending writ petition prior to that. Otherwise not. Now that writ petition which you ultimately take part.
Yes, this was filed in the year March 2025. The initial order is 26th April 2024. They are just sitting and watching the game. They are the utter fence sitters. They are utter fence sitters.
Mr. Prasad, then you file a short affidavit with the section stay application will be clear.
My lord, kindly consider this issue is subject to correction by your lordship. This issue is already, my lord, considered by the repeatedly, and the coordinate bench has also, my lord, considered this issue and dismissed the writ petition, dismissed the appeal.
The coordinate bench decision is not on my part.
And
my lord.
kindly consider the coordinate bench.
No other point.
There is no merit in the appeal.
In Rakhi Chakraborty's matter, my lord, writ petition
How-
was found prior to cut off
A
date, and it was
pers-
filed after cut off date. That point was
My
considered
lord,
by the division means that it was
panel expire, and we have no right to, my lord, make additional panel repeated. This is in violation of the rule also. And I'm only beseeching, my lord, as this issue has already been gone into deeply, repeatedly, and by the Honorable Supreme Court also, the Supreme Court had not, my lord, interfered in the cutoff. My lord, it could kindly consider.
One 260.
260 of the stay application.
No. 29 শেষ দিনে
কোথায় 25-এ আমার 25 তাও তো নষ্ট হয়নি। আরে পিচ কোর্সে মতলব ভর্তি না হতে পারলে নষ্ট হয়ে যায়। তুমি এটা আরো করছো কেন? হ্যাঁ? হ্যাঁ, আছে।
Your contention is accepted. He had your name within the second panel of 2025.
Yes.
Then also you could have some right.
in the panel, my lord, I could have been appointed by this.
Huh?
Since panel published and appointment has been given in that
If he is
second panel.
Thousands of cases are there where panel is published appointment.
Yes.
yes, if he is coming within the cutoff, we have no malot issue. If because
Even if he comes within the cutoff,
yes,
they would have culminated in the order of publication of the panel. 2025 panel.
Yes.
If
2025 panel.
Yes.
Prayer was allowed, giving it that he had filed the writ petition.
Yes.
Within time. But that has also culminated by preparation of a fresh panel. Ultimately, that panel also his name does not feature. That is 2025 panel.
Yes, but because 2025 panel malot is to that particular persons of the 26th April 2024 order. And in threat of contempt, we have complied. We have, my lord, continuously fought that we, my lord, there will be opening of
এটা সার্ভিস কমিশন আগে
I'm for the appellant school service. Benefit of service. Judgment is at page 130 of the stay petition. Yes, yes. Read,
You are coming against any issue.
my lord.
What did the court say?
The court has the petitioner, the writ petitioners, they were called for counseling in the first phase. This is relating to the upper primary matters. But they remained absent. They did not come. Then second phase, third phase, fourth phase was going on. They filed the writ petition sometime when the seventh phase was going on. Ultimately, the prayer was to participate in the eighth phase, which is our last phase. Court did not allow participation in the eighth phase, but because that was on the very next day, But the court said that in the next phase, yes, they are to be called. Now, the rule, it's just one line argument, basically. The rule provides a statutory bar that an absentee candidate will not get a second opportunity. This is this rule. Now, first phase counseling, they remained absent. 7 phases of counseling went by. Ultimately, the court has held that when you call the 9th phase counseling, they are to be allowed to participate. Now, the fact that this is an interim order, normally I would not have come up in appeal because I wanted to contest it before the single judge. And if ultimately, if I fail, then I would have come up in appeal maybe. But subsequently, the court, following this order and relying upon another order also, has started giving mandatory orders. And now there are total of at least more than 30 matters where we have mandatory orders disposing of the writ petitions. Against those also, I have filed an appeal in one. The others, I have not yet received the certified copies. And I did not want to trouble the court asking for leave in all the so many matters. What
order you have complied?
Yes, that has been recorded.
Order we
complied with. That has been recorded in the
order we complied with only in case of the interim order which was given.
It is also interim order.
That was complied with the interim order.
How can you prevent this?
No, I have complied with it.
Accepted the order and granted counseling to persons similarly situated.
No, but now the court is granting mandatory orders. That is why I have now had to change. Previously, what was the order? The order which the court...
As in compliance of the court's order, in respect of similarly situated person, some orders have been complied. Now, what is the difference between those persons and these persons? If there is no difference, we have to
That is one aspect. That is absolutely, that is a hurdle I have to cross. That is a hurdle I have to cross. But
now, when is your next counsel?
It has not yet been fixed, my Lord. Justice Chakraborty will remember that in the contempt your Lord has allowed us, your Lordships have allowed us to approach the Education Department to give 1241.
So if that is not done, then there will be no further counseling also.
No, but possibly the nature of this order is such that if there is no further counseling,
these vacancies are, if they are allowed to be counseling, since they did not appear at the first phase. Now, if they fill up the vacancy, who will be different?
the waitlisted candidates, that specific case I have made out, that and at that juncture when their right has now crystallized, I have exhausted all the previous candidates, the higher ranked candidates. A set of candidates are in the waiting.
What was the reason given by them for not appearing?
The order records, no proper reason has been given, but the fact is
this ballot, their service are being loosed by the order of the Supreme Court. They were the 9-10 candidates. Now these are the upper primary. They have taken a part in the upper primary selection process and they become successful. Now, because of the matter was pending before the Supreme Court and we are working, but we have lost, we are in service candidate, lost our case.
No, pending before Supreme Court, which one?
These persons,
This is upper primary.
the 2016 selection process, it was challenged before the, up to the Supreme Court.
Classes 9-10.
Oh, that's
That
9 and 10.
said 9-10,
Was
11.
also 9-10.
No, we are working 19, but we have lost our service. Now we are also empaneled candidate in the upper primary, and we are called for counseling. At that juncture, my lord, we are in the service, and we could not participate at the time of counseling. Now that's why, my lord, we approach before this court. Kindly permit us. This is the actual scenario. The Supreme Court passed an order, cancelling the entire selection process. We are jobless, so we have no other alternative than to approach the court. The court passed an order and court considered the same. Similarly,
You were in the tented group or
no,
non-tented?
no, not tented. Tented or, if it is a tented, I would not have appeared before your lordships. These are not the tented group. This is not the case that the tented candidate are there. They have been allowed. They are not the tented candidates.
No, if in the 2012 process you have been appointed, then
2016.
Sorry, 2016.
Yes.
That 26,000 candidates were
Yes.
taken out.
Yes.
You were pertaining to that selection process.
Yes, our
Appointment has gone.
Hmm. Now your lordships kindly have.
My lord, may I just
Page
interrupt my
135,
learned friend?
page 135 of the.
My lord, may I
Admin,
interrupt my
admin,
learned friend?
Dr. Patra, admin.
Because the reason for not allowing,
And
or
everything has
the
been
reason
quoted.
for allowing was not loss of jobs. The
130
reason why the court allowed,
Place the case.
Page 135, your lordships kindly have it. Internal page 6.
Yes.
On query being raised by this court, Dr. Patro, learned counsel appearing for the commission has informed this court. No appeal has been carried out by the commission from the order dated June 9, 2000 in the matter of Mukti Vishwas versus State of West Bengal, rendered WPA number such and such. In his usual fairness, he also submits the factual position in respect of the situation of this petitioner in this writ petition are similar with the writ petition in the matter of Mukti Vishwas. Then Dr. Patro opposed the prayer. Your lordships kindly have a look to this. Page 139. Page 139. The relevant rules from the said 2016 rule which imposed a bar according to Dr. Patro to allow in absentee candidates in the second counseling cannot be taken as a plea before this court at this stage when the direction of the Honorable Division Bench is already there. Similarly, from the
What
order
direction of division bench?
your lordships directions that the to echo 14,000
that is what I am trying to
should be
submit.
should be given all. We are in the 14,000. We are selected candidate within the 14,000. Now they're already there. Similarly, from the order dated 9 June passed by the coordinate bench in the matter of Mukti Vishwas, it appears that the commission has raised the same issue that an absentee candidate is not allowed for the second phase of counseling, but the order was passed by the coordinate bench allowing the writ petitioner therein to take part in the forthcoming counseling. It is true this was an interim order, but no appeal has been carried out by the commission. The writ petitioner there had also not been called upon seventh phase of counseling. Thus, the commission had accepted the said interim order and acted thereupon. Similar circumstances.
Acceptance of an interim order does not give a legal right.
Accepted, you have allowed.
It was without prejudice.
And no appeal has been carried out.
Yes, it was without prejudice. We were contesting. My lord, may I just point out a few things because my learned friend has read the paragraphs which will help him. Let me. The reason why the court allowed was not loss of jobs.
Where is that Mukti Vishwas?
Mukti Vishwas, your lordships can.
My lord, kindly first let me just place two facts before looking at the judgment. Page 139. The very first line I am reading from the very first line. No cogent and sufficient reasons or explanation in the eyes of law according to this court has been shown on behalf of the petitioners in the writ petition as to why they were absent in the first phase counseling. Loss of jobs was not accepted by at least by this court. That did not bring any sympathy or any right in favor of the petitioners. Why did the court allow in this particular matter, before we look at the other matters? Because your lordships had directed us to give appointment to 14052 empaneled candidates, or rather merit listed candidates. Our argument reply to this is that yes, that direction is there. We are carrying it out in its letter and spirit. We called them for the first phase counseling. They remained absent. So our obligation got discharged and they lost their legal right to participate further. As far as all absentee candidates are concerned, we have done our duty. We have complied with the order. It was their choice to remain absent. This was the argument. But the learned single judge said, no, since the order said 14052, so you have to bring them back. Kindly see the judgment, the part where the court has, now page 139, the bottom. Considering the special and peculiar circumstances, may I read it?
Yes.
Relating to the self-same selection process as discussed above, and in view of the direction of the Honorable Division Bench in the matter of Rajiv Brahma and others, supra, the court is of the considered view that one further opportunity should be granted to the petitioners to participate in the counseling process. Prima facie case and balance of convenience and inconvenience also warrants for such opportunity.
No, Dr. Patro, we will say that writ petition is pending. We will say allow them in counseling and their appointment confirmation will be subject to the result of the writ petition.
That is already there. That is already there.
Then what can be the problem?
No,
Suppose
the problem is
by allowing them participation, whose right at best can be affected? By the persons in the waitlisted candidate.
Yes.
Because due to their non-appearance, they came within the zone of consideration.
Yes.
So, if this order is passed that their appointment will be subject to the result of the writ petition, if any waitlisted candidate finds that by this order they have been prejudiced, naturally they will come and get themselves joined in the petition and have the matter heard out.
No, the difficulty is in this petition alone there are 20 candidates.
Now, only
if we start allowing,
the problem is your contention is right that how many times we will permit. We have called
and they're walking in casually. They lost their jobs. If I go back to the main,
when did they lose the job? Prior to the date of first counseling?
No. But they lost their jobs on 3rd of April. 3rd April 2025 was the judgment of the Honorable Supreme Court. After that, at least 4 rounds of counseling were held. 4th, 5th, 6th, 7th. They have casually come. Someone comes for 6, someone comes for 7, 8 also, and now 9th. This we had also. When do we stop? Now we have run out of vacancies. Your lordships have given us the liberty, or rather the direction upon the education department to give the exact number of vacancies equal to the leftover candidates.
No.
You were working in the.
Well, your lordships kindly have a look to the Mukti Bishas, everything has been recorded.
No,
Exactly,
we are asking, you could not participate in the counseling since you were working at a particular post. That post, that job you have lost pursuant to order of 3rd April. So you must be within the tented,
No,
untented.
we are not the tented candidate.
How we will understand that?
Because we have been allowed to work up to 31st December. Those the tented candidate lost their job immediately, but the untented candidate were allowed to work till 31st December. Your lordship kindly have a
Now,
look. to me.
then are you now participating in the fresh selection process pertaining to that examination, which is being held?
No. Because we have already been, my lord, the selected candidates in the upper primary. That is our case.
No,
Your
no, let
lordship
my
can-
learned friend take instruction.
Your lordship kindly
20
have,
candidates,
Your
they
lordship kindly
have not participated in the fresh selection process. That is not possible. It is not possible because the Supreme Court has given them all types of relaxations. Even age bar will not stand in the way. They are getting 10 marks grace for being in service as per the rules.
No, we are wanting to know that their services against the order which was passed, their services were left undisturbed till 31st of December.
right.
Now those persons, ওদেরকে
Your
they
lordship
also-
kindly have a look to this order, Mukti Biswas. Everything has been quoted. Mukti Biswas. Your lordship kindly have a look.
All right, Mr. Buddy, we shall go through it. Come on, next. চলো দেখে আসি।
Okay.
My lord, may we
Tomorrow.
come back tomorrow?
Day after tomorrow.
Day after tomorrow. Very well.
আসো দেখি। Yeah.
সিট আছে বর্তমানে 5,000 সিট আছে 1400 ক্যান্ডিডেট
তাহলে
1300 ক্যান্ডিডেট হ্যাঁ ওই তো আপনাদের 5,000 সিট আছে সেটাই তো কন্টেম্পোরারি ওভারঅল 1300
Corrected note আছে
হ্যাঁ
বল I was asked to come at 2 p.m.
খবর পেলেন
আমার ব্রিফটা দাও
কবে আসবে ভাই
আপনাদের তো দিয়ে দিয়েছে তো বুঝি ইস বাবা। হুম এই তো
You have finished, Mr.
But I have finished, but I have made a little bit of change in my law notes. That I am giving to your lordship.
হবে একটা কপি
দিয়েছে তো তো?
চেঞ্জ করার পরে
সব দিয়ে দিয়েছি
দিয়েছে।
চেঞ্জ করার পরেও
হ্যাঁ
না দেখলে কি করে
আরে বাবা কি
দেখো, দেখে দিয়ে বলো
না না চেঞ্জ কর বাবা কি দিচ্ছে
দেখো পড়ো তারপর বলো
জীবন একটা ঠিক কাজ করে না না চেঞ্জ করার পরে সেটা করবো। আরে বাবা হ্যাঁ দিয়েছে ধরে নে শিলাদি বলছে
দোষ দিবেন না
এটা তো just a-
কথাটাকে চোখা বলে
Yes, what change?
My lord, I am giving, I have made it again. Press note, my lord, I have made. Only one, my lord,
পাওয়া দরকার
an additional judgment I have given on the question of limitation. Year 2023 Calcutta, Justice Somensen
ডিভিশন বেঞ্চ
in the division bench.
That you have annexed.
Yes,
লাইক সেটা লাইক
that was not there, my lord, in the original note. That is one. Other thing is,
এইট সুপ্রিম কোর্ট
কোনটা? Another thing is, your lordship kindly turn to my
That explains.
previous note, my lord, your lordship kindly turn the last one. Last contention, my lord. That is with regard to Hindu Succession Act. Your lordship had the
Paragraph,
previous note,
previously what, paragraph 4?
paragraph 4, yes. কোনটা গো?
That is life interest of the widows.
Yes, that, my lord, I am not, that point I am not pressing. I am given it, it has recasted by me, my lord, in the new note.
New one, which paragraph?
My lord, page 4, my lord. Page 4 of the,
Hmm. The last point pleaded.
yes, last point pleaded for your lordship's consideration is that application for probate being hopelessly time barred and having dismissed for non-prosecution all the natural heirs of the testator succeeded to the estate of the testator as per provisions of Hindu succession right, considering that succession cannot be kept in abeyance, it vests in the person who are entitled to get it under the law. These are my submissions.
So that
That
Moment of
14
two
to my lord, I am not pressing it. And one judgment, my lord, my junior on this point, on the last point, my lord, I shall supply, my lord, AIR 2008 Supreme Court.
In today's note,
AIR 2008 Supreme Court 1467.
in today's note.
Today's note. Last point.
limitation 1467.
1467.
So you
That it will be, if the will is not provided, then my lord, the natural heirs will get it according to.
I think that's an accepted proposition.
That is, I've given one.
now what do you want to point out from this judgment which you have annexed of Justice this Guru Prasad Ta?
That is on limitation, my lord. I have already considering all the Supreme Court judgments which I have cited.
Can you give us the relevant paragraphs of
Yes.
this judgment?
28 দেখুন তো 28 nothing new.
Just a minute, my lord, I'm giving it. কোথা থেকে paragraph গুলো? Previous paragraphs, my lord, considering the earlier judgments, which I have already cited.
Give us the paragraph.
ওটা প্যারাগ্রাফ 28 দেখুন তো এখান থেকে 28 28 30 এই দুটো মনে হচ্ছে
30, 33, 37.
From 30 onwards. These are my submissions.
Yes, Mr.
কি দেবো? কেন?
যাবে না ও যাবে
My lord, Mr. Basu asking me to go outside this courtroom. I do not know.
You should know.
চলে যাবো?
বলে ভালো হয়
মারবে
my lord is hearing a probate proceeding
কি হবে? টানছো কেন?
where my lord execution the probate court can look into whether this is properly executed or that execution is surrounded by any suspicious circumstances. So far as title is concerned, my lord, probate court cannot go into that question of title. Even if title is not passing, then also court is limited scope to look into it whether this execution is proper and the witness here. If your lordship kindly see the will, your lordship will find there is a gift deed simultaneously executed along with the registration of the will. This gift deed is being accepted. Execution of the gift deed and everything was accepted. If that be so, our first contention is you cannot argue that the will has not been properly executed. But for the will, that gift deed is not there. In the will itself, recital says the property will be vested and accordingly gift deed has been executed on that same date. And both are registered deed. So if this contention is accepted or mine, my lord, then only point left out is limitation.
So So if gift deed execution has been accepted, this probate cannot be proceeded with pertaining to the will. Property
Probate
pertaining
will,
to the will.
execution of the will cannot be questioned because the gift deed was simultaneously executed with the will.
Same particular property.
Same scribe, same witness. This deed, gift deed, acted upon, accepted. So, my lord, on the self-save debt, the one part you will accept, other part you will not accept, my lord, that is not possible. Now, fast, my lord, I will not take much time. Kindly take trouble to see the will itself, which is registered deed. এইটা আমার কিন্তু part two। এটা type copy। আমার এখান থেকে সুবিধা, আমি এটা মার্ক করেছি। হ্যাঁ, part two। এটা mark করিনি, that's the problem।
The give, Mr. Vasu, the gift deed property, that is in the will, it is the same property or something more.
Some other property. One of the point was that একই তো decide।
Next.
It may be one of the ingredients to hold a suspicious circumstances. One of the ingredients. As a whole, court will find that these four situations which leads to a suspicious circumstances. In isolation, it is also not. That is also limitation also. Limitation, my lord, is not part of the Limitation Act. But finding a document after a long time may lead to one of the ground to hold this is suspicious circumstances. Now, so far as the will, my lord, can I take trouble to see supplementary paper book, that is a thinner one. You'll also kindly come to page 3. হ্যাঁ, দেখেছেন আপনি, আমি জাস্ট রিক্যাপ করি।
Page 3.
Page 3 of the supplementary paper. One line I will read, my lord. আমার পত্নী শ্রীমতী দয়াময়ী থেকে পৃথক দানপত্র দলিল মূলে এই উইলের সত্যভূত হওয়ার সম্পত্তি দান করিয়া দিলাম। 3, page 3, top. Yes, 3. Yes, Mr. Kali got it. At the top. Kindly come to, and that is the deed. Executed simultaneously on the same day.
Same scribe.
Same scribe. Same scribe, same witness.
Vasu.
যেটা বললাম।
My lord is asking.
Eight, 9, 10, 11, 13. 13 line from top. It starts with আমার মৃত্যু হইলে বা কোন রকম মাত্র নিঃসন্তানবতী পত্নী রইয়া আমার মৃত্যু হইলে আমার নিম্নের গতশীলে সম্পত্তি বর্ণিত তাহাতে আমার ভ্রাতা শ্রী কার্তিক লাল সাউ বা তাহার অভাবে তার ওয়ারসের পুত্রগণ নিগ্রহ সত্ত্বে প্রাপ্ত হইবেন। শ্রী সন্তোষলাল সাউ বিবাহিত হইয়া পত্নী শ্রী সচেতন কারণে মৃত্যু হইলে তাহার গতশীল বর্ণিত সম্পত্তি বসবাস করিতে পারিবেন। Now, in terms of this, another deed have been executed that your lordship will get at page, the main paper book, page 3, exhibit 3. হ্যাঁ, আগে দিন একটা গন্ডগোল হচ্ছিল।
আমার পেপার বুকের উল্টা
ওটা নয়, ওটা আলাদা আগে কত কত পাতা হবে বলতো? ওই যে ওইটা কাইন্ডলি কাম টু এটা কার্তিক কি লিখছে এখানে পেজ 9
no just read this portion once more, page 3 what you just read. Just read it slowly, we are not understanding this.
Mr. Raya
মহাদেব
তো বাবা
এইখানে এইখান থেকে সন্তোষলাল সাহের মৃত্যু হইলে বা কোনো
কত পেজ? ও সাপ্লিমেন্ট পেপার দিলে এটা স্ত্রী জীবিত আছে, এই দুই স্ত্রীর মধ্যে স্ত্রী রাজলক্ষ্মী দুই কার্তিক আর কার্তিক এটা কি শ্রী মহাদেব বলেছিল এখানে
এইখানে এইটা
ইংরেজির এত তারিখে আমার দুই স্ত্রী
আরেকটু উপরে পড়ছে।
আচ্ছা, রাজলক্ষ্মীর গর্ভে আমার দুই পুত্র কার্তিক হাউ মহাদেব, it should be কার্তিক
and সন্তোষ।
নিম্নের গতশীল বর্ণিত সম্পত্তি তাহার ভ্রাতা শ্রী কার্তিকলাল সাউ বা তাহার অভাবে তাহার ওয়ারিশ পুত্রগণ নির্ভর সত্ত্বে প্রাপ্ত।
না তার আগে
11th line
এই যে আমার দ্বিতীয় স্ত্রীর গর্ভে দুই পুত্র, গট ইট?
আমার মৃত্যান্তে
আমার the 11th line you read from
যুক্তি নিগুড় সত্ত্বে প্রাপ্ত হইবে, that line starts with the
no page 2 you are seeing
page 2
হ্যাঁ
we are as page C
এইটাই এটা দুই পুত্র
না এইটা
The lordship is reading from page 3.
you are showing page 3.
3 at the top first line is that Dayamoyi. May I mark the portion? Chakraborty, may I mark the portion which I will rely?
No, we have got it. You are reading page 3 first line.
First line, there my lord will get
আমার অপর স্ত্রী দয়াময়ী।
আমার অবশ্যই শ্রীমতী
ঠিক আছে।
দয়াময়ী সাহের গর্ভে এক পুত্র শ্রী তুলসীলাল সাউ জন্মগ্রহণ করিয়াছে।
That is page 2. That is my lord is reading page 2.
page 2 তে চলে গেছে।
পেজ 2 তে চলে গেছে।
Tell us which part?
What I was relying on, that is page 3.
Yes.
And Bhajati Chakraborty asking something else.
Now, page 2, at one position, it is stated that Rajlokshir গর্ভে আমার দুই পুত্র কার্তিক এবং মহাদেব. মহাদেব cannot be the পুত্র.
No.
So it just
এইখানে আছে।
second page, first, second, third, fourth, fifth, sixth, seventh, eighth, 9, 10, 11, 12. 12th line.
এটা হচ্ছে ব্র্যাকেটে আছে শ্রী মহাদেবলাল সাউ।
আমার স্ত্রী রাজলক্ষ্মী
হ্যাঁ,
দ্বিতীয় পৃষ্ঠায় শ্রী
গর্ভে দুই পুত্র
কার্তিক
মহাদেব এই যে।
কার্তিক এবং এই
Oh,
মহাদেব
this is in bracket.
that is on a signature which has been marked second page, my lord. This is SD. That is why it cannot be turned in such a manner. My lord will find all the signatures. It has been mentioned in. That is why it is within the bracket. Mahadev Lal Shah is the executive.
He's the father.
Father is the executor.
Sons, 2 daughters.
Yes.
He's the testator. He's not the executor. He's the testator.
That's why.
He's the testator. not-
Testator. He's the testator. That's why the
আরেকটা কপি আছে,
testator.
আরেকটা কপি দিতে।
Yes. Testator. This signature that has been marked as SD.
Well, kindly for your lordship assistance.
তোমাকে দিচ্ছি
আর দিতে হবে।
We've got this, Mr.
we have got this from this.
Yes.
This list of dates is helpful.
Yes, now let us go to page 3. What you are showing?
3, my lord. We want
13th
to
line.
we want to show to your lordship.
Uh,
First line is Dayamoyi's.
yes.
Dayamoyi's rice preserved.
And
Dayamoyi's, he was not deprived. Then, my lord, kindly come to 13th line from top. Here also, my lord, Katrik also. Some,
আমার মৃত্যু হইলে,
yes.
প্লিজ রিড ইট, আমার নিম্নের গসতফশীল সম্পত্তি
সম্পত্তি তাহার ভাতা।
তার ভ্রাতা শ্রী কার্তিক লাল সাউ বা তাহার অভাবে তার ওয়ারিশ পুত্রগণ নির্ভর সূত্রে প্রাপ্ত হইবে।
হ্যাঁ,
শ্রী সন্তোষলাল সাউ বিবাহিত হইয়া পত্নী নিঃসন্তানবতী থাকা কালে মৃত্যু হইলে তার পত্নী গতফশীল বর্ণিত অন্তর্গত বাড়িতে বসবাস করিতে পারিবে, কিন্তু এবং ভরণ পোষণ বাবদ গতফশীলের জমির উপরস্থ ভোগ দখল করিতে তাহার উক্ত সম্পত্তির কোনো সত্ত্ব থাকিবে না, বা তিনি ওই সম্পত্তি কোনো প্রকার হস্তান্তর করিতে পারবে না। আমার কন্যাগণকে এই উইলের বিধান মতে যে সম্পত্তি দেওয়া হইল তার মধ্যে সরস্বতী সাউ এর বৃত্তান্তে নিম্ন খতশীল বর্ণিত সম্পত্তি তাহার সন্তান
সন্তানগণ।
5. Now, there is a map is there after that.
ওইখানে স্টপ কর, ওইখানে এবার দেখ এটা। এইটা দেখ।
কার্তিকের স্ত্রী। আচ্ছা আচ্ছা।
বাড়ির সম্বন্ধে
না, ওইটাতে ঢুকিয়ে দিয়েছি।
টাকা যে ব্যবস্থা করা হইয়াছে ওই টাকা দ্বারা যে বাটির খরিদ করিয়া দেওয়া হইবে।
দিয়ে দিল টাকা দিয়ে।
না, বাটি শাসন মাতা ধর্মেশায়ের সত্ত্বে আমার কনিষ্ঠ এইখানে পারিনি
টাকা দিয়ে কিনে,
এই জন্য
টাকা দিয়ে কিনে দিয়েছে।
তারপর আমরা সেই জন্য আমরা যারা ওয়াইস ছিলাম
সন্তোষের দিকে দেখা যাচ্ছে।
এটা সন্তোষের ব্যাচে সন্তোষ সরস্বতী সাধনা একদিকে, কার্তিক মারা গেছে, তার ছেলেরা আর ছেলের মা। সন্তোষ সরস্বতী ঘটনা। সরস্বতী লিগেলের বোন, সরস্বতী এনিওয়ে অ্যাজ এ রাইট। সরস্বতী তো ছিলই, পার্টি তো সোল। এক্সট্রা কেউ অ্যাড হয় সন্তোষের জায়গায়। সরস্বতী আর সাধনা ঠিক আছে, সন্তোষও করেছিল, সন্তোষ যেহেতু মারা গেছে, সরস্বতী আর সাধনা।
সন্তোষ সরস্বতী সাধনা। Yes,
My lord has seen that. Now kindly turn to page 5. Supplementary affidavit, supplementary paper. After the map,
After the map.
yes, after the map.
Five. Yes.
Got it. 3 আমার উপরোক্ত দুই কন্যা মাইনর from the second line middle minor defined 3 is there আমার উপরোক্ত দুই কন্যা উপযুক্ত পাত্রাভাবে এবং এত পাত্রাভাবে অভাবিতা আছেন আমার মৃত্যুকালে তার উক্ত দুই কন্যা বা ওই দুই কন্যার মধ্যে যে কোনো কন্যা অভাবিত থাকিলে
অবিবাহিত
অবিবাহিত থাকিলে
অবহিত না, অবহিত is other thing.
অবিবাহিত বলেছি
না Yes, that is why he corrected. Yes.
আসতে পর ছটফট করে থাকিলে তাহার বিবাহ খরচ
ও বিবাহ সংক্রান্ত অন্যান্য খরচ বাবদ
বিবাহ খরচ জন্য আমার জ্যেষ্ঠ পুত্র শ্রী কার্তিক লাল সাউকে page 9 কার্তিক সাউ আমালিকা I will not place entirety. I will show to your lordship who is giving and who is getting in tune with the will. This is accepted.
Page 9.
Page 9.
Who is getting and who is giving what? Where?
My lord we have placed this, my lord, this recital how it will be purchased, it cannot be purchased, whatever. So this has requires an execution. During the lifetime, this money was. So that execution is here. And it is mentioned the deed about this will. In this deed, you will also will find that deed, will has been mentioned. Next page.
This is the will, or is this the gift deed?
This is the deed. Oh, may I repeat? I have shown to your lordship the recitals in the will. Page 5. This is the will, supplementary affidavit, supplementary paper.
The will.
That is the gift deed to the second wife.
That I'm saying. They said second. This one.
Just now said it's the will.
No, will is supplementary paper book.
We are on the supplementary.
No, on the basis of that, kindly come to main paper book.
You showed us just now the will at supplementary paper book.
I say supplementary paper book contains the will.
And it contains certain dispositions. These
Right,
dispositions
that
are
disposition is here.
in the gift deed. This is what you're saying. And therefore, if one accepts the gift deed, necessarily will have to
Necessarily corollary is that we cannot deny that.
Page 9, what you are.
Page 9, my lord, kindly see who is Grohita. Nabalok Tulsi Lal Sao Pokke Guardian Mata. O Soyong. See,
No, where you are reading? Page 9 of what you are reading?
main paper book part 2.
Say that we are on part 1, part 2, page 9.
Exhibit 3.
Exhibit 3.
This is exhibit
Exhibit 3.
3.
Exhibit 4.
Exhibit 3.
Yes, that was on the other day it was pointed out. Exhibit 4.
4. হ্যাঁ ওটা ভুল করে লেখা আছে exhibit 4.
This is the gift deed.
This is the gift deed. I say in
gift.
Yes, in consonance, in the tune with the will.
Second gift.
Who is this Data? Kartik Lal.
Second gift deedটা হলো 63. সেখানে সব ছেলেরা আর মেয়েরা আর ফার্স্ট
মেয়েও আছে নাকি? মেয়ের নাম কি?
গিফট করলো দয়াময়ীকে।
Who is Grohita?
Who is?
Grohita.
Grohita is Nabalok Tulsi.
Yes. So then, okay, guardian, Mata, O Soyong, see Doyamoyi. And kindly see who is granted. Include the objectors. So if the objectors were executed deed will, which in tune with the will, this document, and recital says so. Kindly come to the next page. এক নম্বর দলিল দাতার পিতা অধুনা মৃত মহাদেবলাল সাউ 1367 তারিখে যে রেজিস্ট্রিকৃত উইল করিয়া পরলোক গমন।
This gift deed execution was what? 63.
আপনি 12 63 এটা হচ্ছে 60 ফার্স্ট গিফট ডিড হচ্ছে সেম ডে 15th October 6 করেছিল
Yes.
First deed executed by the. Then, my lord, kindly turn over the page. Page 9, I have shown to your lordship. Who are the grantor and who are the receiver? Your lordship will find, including the objectors. Who are the objectors before my lord? Yes. My lord, kindly see in the recital also mentioned that who is the executor of the will. That is also mentioned. See, Mahadev Lal Sao, will executor. As my lord, kindly got it. Then kindly turn over the page. এক নম্বর দলিল পিতা অধুনামৃত মহাদেবলাল সাউ 1367 আশ্বিন 1960 তারিখে যে রেজিস্ট্রিকৃত উইল করিয়া পরলোক গমন করিয়াছেন উক্ত উইলের 3 এবং 9 নম্বর দফার বর্ণিত মত আপনাদিগের not necessary because I want to show to your lordship.
It says in terms of the will.
Right, this I want to show, nothing else. And the objectors are the party.
Yes.
After this, my lord, in my humble submission, nothing remains to be decided whether the will has been executed, there is surplus of circumstances, nothing to be decided by the court. Because objector accepted that in terms of the will. So existence of will, they admitted.
So at this stage, non-genuinity of the will.
He cannot question, the objector cannot question even. But court has a duty in a proceeding, for a probate proceeding, to be satisfied. That I am not questioning. Court has a power, even if not objected to, that whether the will was executed. And my duty is to, in any circumstances suspicious comes in, I have to discharge the onus that is not clouded with suspicious circumstances.
Hmm.
Now, my lord, kindly see what is the objection.